Good morning, everyone, and welcome to our webinar today. On behalf of Women in Planning, it's wonderful to see so many of you here, and apologies to those who tried to log on last time and couldn't get in. I don't think we've got that problem anymore. You'll see the chat and question feature, and please feel free to use those to talk to us, to ask any questions, and we'll try and answer them if we can, albeit it's a little bit hard while we're presenting, so we might just pick up some of the best and respond to them later on our LinkedIn pages, or perhaps through different No5 channels. For those of you who don't know me, I am Thea Osman-Smith. I'm a barrister at No5 Chambers in the Planning and Environmental Law Group. I'm also a proud member of the Women in Planning West Midlands Committee. Today, the focus is on the Environment Bill and environmental cases that you want to know about in practice. So first of all, Nina is going to be talking to you about the Environment Bill. Nina practices exclusively in planning and related areas of law, specialising in environmental law. Nina has acted in some of the leading strategic environmental law cases of the past few years, including appearing before the Aarhus Convention Compliance Committee and also acting in the Friends of the Earth claim that the National Planning Policy Framework ought to have undergone strategic environmental assessment. Nina serves as a board member and trustee of the United Kingdom Environmental Law Association and as a member of the advisory legal panel of the Broadway Initiative, representing the business sector on the development of environmental law post-Brexit. Then Leanne's going to be kicking off with a case law update. Leanne is a specialist planning and housing practitioner, previously recognised as one of Planning Magazine's top planning juniors under 35, and by the RTPI's The Planner magazine on their 2018 Women of Influence list. She advises and represents developers, local planning authorities and Rule 6 parties in all courts and tribunals on a broad range of planning matters with a particular interest in residential schemes. Outside of litigation, she's an active member of the RTPI as past chair of the South Coast Young Planners Network, judge of the Awards for Planning Excellence, and has also appeared on their Agent Planet radio show to encourage school-age children to engage with planning. And after that, I'll be rounding up with a little bit on habitats and EIA. So without further ado, I shall pass over to Nina, who's going to show you some brilliant slides, including pictures of her wonderful Oxfordshire or Oxford town, home city, and see you all in due course. Nina.
Thank you, Thea. And I'm just going to remember how to screen share. There we are. This picture, incidentally, while I figured this out, was taken just after I'd run straight into a bog up to my hip. But enough about what an idiot I am. Here we are at the Environment Bill. Thea, can you give me a thumbs up if you can see that? Brilliant. So I'm going to speak to you about the Environment Bill 2019-2020. Going straight into the structure of the bill, this is a framework bill. So it sets out general provisions with the detail, much of the detail, which will be filled in later. And of that detail, a lot will be through statutory instruments. So we know the framework, but the detail we don't have very much information on at all. It sets out the provision for targets, both long-term and interim. And one of the most positive features of the bill, in my view, is the provision for environmental improvement plans, which will aim to be comprehensive plans to improve the environment in a joined-up, data-driven way. There's also provision for principles and policy statement. Unfortunately, we don't know what that is yet, despite lots of us asking to see that, as so much hangs on that. So that will be how the principles which are already set out in the bill are going to be interpreted and applied by all government ministers, so not just the Secretary of State for the Environment, but all government ministers will have to have regard to that statement when it's brought out. Now, the principles, then sets out the provision of the Office for Environmental Protection, and that's what I'm going to focus a lot of my talk on today. Because obviously a lot of people are concerned about what that means for them and their clients. And then there's sections dealing with waste, air quality, water, biodiversity, all unexpected. I'll touch briefly on biodiversity today. One thing to mention about the structure of the bill, that there's no overarching objective committing to a high level of environmental protection. That has been asked for repeatedly by pretty much all consultees on the bill, mostly because there is so much discretion inherent with the within the bill. So it should help to guide the exercise of that discretion, but also because as a new regime, there will be gaps and they will be filled by the court inevitably through litigation. And so if there is an express objective on the face of the bill, that will help the courts understand what the intention of the legislature was when they drafted that provision. Very encouragingly, just before lockdown was announced, it looks like the wording that was suggested for an objective by the Broadway Initiative was being considered positively for inclusion in the bill, word for word. So that was the proposal before Parliament at that time, and then lockdown took place. So unfortunately, I don't know where we are with that. What I do know is at the last moment that they're working on the bill, they're going through line by line scrutiny. I heard that they'd gotten up to about line 20, so not very far at all. And from my understanding, that's where things are left. Obviously, the government has other much more pressing priorities right now. Second key thing is that there's no commitment to non-regression. I've been told by someone at DEFRA that this was because it was considered just too difficult to draft. I don't buy that at all. There is some talk about the EU requiring a commitment like this during the trade talks that may or may not take place next month. So we will have to keep an eye on that and what the EU requires in exchange for access to their markets. Now, environmental improvement plans, these are long-term plans to take place over a 15-year at least time period with the express intention to significantly improve the environment. There are interesting questions on how that will translate to the spatial level. Are there going to be evidence documents for local plan purposes, for example? We don't know, and it'll be interesting to see how influential they are within local planning authority decision-making. What we do know is what the very first environmental improvement plan will be, because that's already published. In fact, before the entire bill was published, we had the 25-year environment plan, and that is the first environmental improvement plan. So at least we have that clarity. Now, the Office for Environmental Protection. The main concern about this amongst commentators is the lack of independence for it. There are calls for the chair in particular to be appointed directly by Parliament. That's not been taken through. The chair and the executive are going to be appointed by the Secretary of State. And that matters because the chair, particularly the first chair, has such a crucial role for the OEP. The first chair will set out the strategy, the ambition, the directive, and the scope of the enforcement activities that the OEP will undertake. And of course, there being a new regime, as I said, there will be lots of gaps, not all of which will be filled by litigation. Many of them, hopefully, will be filled by the actual OEP itself, setting out policy and guidance on how it will exercise its functions. And that will all be the initiative of the very first chair. There are rumours, very strong rumours on who the first chair will be, but it wouldn't be appropriate for me to say who that is now because I understand that will be announced. It was supposed to be announced in any event this summer, so we should hear probably by July if that actually will happen, if that announcement will be made. But we do know it'll be based in Bristol, and the plan is for around 80 staff members there, although with post-COVID public finances, that may be up for debate. We do know it won't be up and running by January 2021 when the present environmental law regime ends, because we're no longer part of the EU, of course, and that has been confirmed. So there will be an interim provision for a CEO in the meantime while it gets up and running, and we'll have to see how they fill that time period between being up and running and the end of the year. What we do know is that there's absolutely, the existing standards will roll over. So when your clients are asking, what does that mean, that gap period between the end of the year and the OEP actually said carrying out enforcement functions, the same standards will roll over. So Water Framework Directive, Air Quality Directive, etc., those aren't going anywhere. They will remain standards for the purposes of decision makers domestically. In their enforcement role, the key provisions are here. So if there is a public authority which has failed to comply with environmental law, then the OEP has discretion to enforce. Public authority is defined as a body carrying out function of a public nature. Now, we see this phrase with quite often in legislation. The case law on it means effectively it means you can be a public authority for some things, but not other actions that you undertake. So really, it all depends on the circumstances. Inevitably, this will be litigated. Although, interestingly, the DEFRA spokesperson publicly said that their view is that statutory undertakers such as water and energy companies are public authorities for the purposes of the Environment Bill. But when statutory undertakers who were listening to that said, "This is news to us, can you please confirm this is true?" There was some rowing back of that. So it's not quite clear, but it looks like DEFRA considers that the statutory undertakers are public authorities. And when you look at what activities they undertake, it does make sense that they would be caught by those provisions. What environmental law is defined as is interesting. So that's something law mainly concerned with environmental protection. Now, all of us as planners understand that to include planning. DEFRA doesn't. And that has been hugely controversial. None of us understand it. And it has been pointed out to DEFRA by me, amongst others, that no less an authority than Lord Justice Sullivan in Venn, you've got the citation there, said quite clearly that Parliament has chosen to implement much of the UK's environmental protection through the town and country planning system. So notwithstanding that being pointed out to DEFRA, and the select committee is also making this point, that's not been carried through. So we shall see. That will undoubtedly be litigated, because the exclusion of planning is not expressed within the bill. It's set out in the explanatory documents for the bill. So that's what's being said on the side effectively, but the bill itself is limited to what is mainly concerned with environmental protection. And I think all of us would say that planning, to a large extent, could arguably be mainly concerned with environmental protection. So real hotspots here: what is a public authority? And what does mainly concerned with environmental protection mean? Does that include planning? We will see, undoubtedly, through the court system. To continue with the enforcement role, this is going to be really transparent. So when the OEP is up and running and we've got a chair and the executive in place and all the employees have had time to bed in, we will have a strategy setting out how its enforcement functions will be carried out. No doubt to manage expectations from NIMBYs on the OEP's activities in relation to the fields they quite like the views over. I should say the OEP will not. It will not descend to the detail of individual fields. That will be very clear. These are for major, serious environmental issues. Now, it will receive complaints from members of the public, but not from public authorities, although an individual member of a public authority can make a complaint as an individual if they wish to. But the OEP does have discretion to investigate in the absence of a complaint. So that will trigger, a complaint will trigger an internal investigation as to whether it should continue to investigate an issue, but it doesn't need a complaint to take action. So that should be borne in mind. After a complaint, there's an ascending level of severity in terms of enforcement. So first, if there is something worth investigating, the OEP can issue an information notice. And if that's not a satisfactory outcome to the problem, then the OEP can issue a non-binding but nonetheless highly consequential decision notice to the public authority describing the breach and the steps that the public authority should take. But first, before a decision notice is issued, the OEP is obliged to serve at least one information notice. And then if it's not satisfied with that, the OEP can then apply to the upper tribunal by way of what's now called the environmental review. So this is an entirely new procedure which relates to conduct before the decision notice has been issued and after the decision notice has been issued. The upper tribunal, importantly, is to consider for itself whether the breach occurred. So it's not limited, it's not a typical judicial review process where you're considering the decision notice itself. You're considering the conduct which led to the decision notice as the upper tribunal. That said, oddly, the upper tribunal is limited by the terms of the bill to applying traditional judicial review principles only. That's odd for a number of reasons. One, because not even High Court judges who are legally qualified can agree on the proper scope of Wednesbury, and yet the express reason for going to the upper tribunal is that we don't have a tribunal composed of legally qualified members, but it includes as well expert lay members. So asking them to understand the scope of Wednesbury when even the High Court judges can't agree on it is asking for trouble. And it also doesn't make principled sense because, of course, those who are involved in environmental information, the environmental information regime, you will know that when we apply to the tribunal system there is a much more intrusive investigation undertaken, and that's Section 58 of FOIA for those who want citations. So it doesn't make much sense practically or principally, but there we are. That's what they've provided. Mandatory remedy if the upper tribunal considers the breach was, in fact, that a breach had occurred, is a statement of non-compliance, and then the upper tribunal is given a range of discretionary remedies which are available under traditional judicial review principles, but not damages, and not if there would be substantial prejudice to third parties, which is really odd and difficult because when almost inevitably we understand planning is included, there will always be substantial prejudice to third parties, and in the case of an environmental permit or a license, for example, there will also be substantial prejudice to a third party. So it seems that this might be a bit of a hollow procedure, given that the actual environmental harm if there is environmental harm, the actual decision which gave rise to the harm, the granting of the permission, the issuing of the license or the permit, will be undisturbed entirely by this whole procedure. But we shall see what emerges from Parliament at the end of the day. Although that said, it's been very clear that the Environment Bill is not really up for discussion now. All the major changes have already been made to it, so we're not expecting huge changes to be made to it now. So it looks like this is something that will be for litigation later on. There's also provision for what I've labelled an emergency application. So if there is a serious failure to comply with environmental law and the OEP considers it's necessary to take action to prevent, mitigate serious damage to the natural environment or human health, then it has express power in the Act to take a statutory review or a judicial review without going through the information notice, decision notice procedure. So it can go straight to the High Court. And in that case, it's worth noting Section 31 of the Senior Courts Act, which gives the court, actually, it's an obligation to refuse leave to apply for judicial review or statutory review if the outcome for the claimant was highly likely to have been the same. That doesn't apply to the OEP in these cases. And if the claim is successful, then the public authority must publish a statement of steps it intends to take within 2 months of that decision. The final point here, despite the fact that decision notices have a serious consequence where you can be hauled before the the upper tribunal, the only way a recipient of a decision notice can challenge it is by way of judicial review, and there's nothing in the bill itself that says Section 31, for example, doesn't apply. So they're in a slightly disadvantaged position compared to the OEP in relation to their options in the courts as a result of a potential breach of environmental law. Now, biodiversity. Very quickly, the net gain requirement is the most talked about. If you Google Environment Bill, biodiversity net gain is the number one topic that comes up. So obviously a lot of concern about what this actually means. When I speak to local planning authorities, all of them say it's because we don't have an ecologist able to devote the time that this requires. So what the net gain requirement is, for those who aren't familiar with it, it will be an automatic condition, just like the time limit condition that's imposed on all planning permissions, that requires a 10% biodiversity net gain to be achieved in relation to all planning consents, not for permitted development and not for nationally significant infrastructure projects, I should add. Now, the NSIP omission was raised by someone in the earlier session, and I had a chance to actually ask the DEFRA lawyer who drafted that provision what happened there. And given that he'll be publicly known, what I can say is the public response to that, which is that it's considered, because net gain is a commitment within the 25-year environment plan, and indeed in some national policy statements themselves, it's considered that it's already covered off, albeit by policy and not by way of a direct amendment to the Planning Act 2008. So interesting. I think we can read into that there was objection within central government to having NSIPs subject to the net gain requirement, but that the plan is for it to apply to NSIPs all the same, albeit by way of policy. There's a question over whether 10% is a minimum or a cap. We'll see how that's worked out in each individual case. And of course, as there always is, there are complaints it's not ambitious enough. So there we are. We'll see whether that's amended or whether we stay at 10% down the line. Natural England, of course, is going to be much more involved now, and they're cognizant of this. They've said that the bill has the potential to be the most significant environmental legislation since the National Parks Act. So let's hope they're resourced appropriately to deal with that, as well as local planning authorities, because they're going to need a lot more ecologists within their planning teams. Now, to conclude, the Environment Bill, it's a framework bill, but what it really does is it establishes a new form of environmental governance, albeit with a huge amount of discretion. So we can see what looks likely to come down the line, but we really have to wait for the detail to be worked out subsequently, which is not ideal in terms of the public understanding of the regime, which applies to something so important to it as the environment. There are worrying features in the amount of discretion, the lack of independence of the Office for Environmental Protection, and the lack of clarity on the regime altogether. Although I do want to say there is a positive feature. Environmental improvement plans are very positive, and the aim to link thinking and targets in relation to environmental protection is really encouraging. But that said, and you probably expect a lawyer to say this, but much of it will be litigated. That's even acknowledged within the explanatory notes to the bill. A lot of it is going to be worked out by the courts. We will be busy, and I suspect the inclusion of planning will be one of the first cases to come before the upper tribunal or the High Court in relation to the new environmental enforcement regime. If anyone doesn't want to ask a question on the chat function but wants to ask me privately, here we are. Yes, I've got my email there, npi@no5.com, and I'm very happy to answer any questions privately if that's preferred.
And I think that's one of your pictures that you've taken as well, isn't it, Nina?
It is. That's my picture.
Near to home.
Although I sadly missed the wisteria. All right, Leanne, I used to know how to do this. How do I stop? Oh, here we are. Sorry, I do know how to do it.
Thanks, Nina.
Thank you very much, Nina. Now, hopefully everyone can now see my slides shared. I'm starting on the case law update and Thea will be taking over after that. Now, I've got about 15 minutes to talk to you about this. I've got 2 cases that I'm going to be discussing, but what I would say is that don't worry, you're going to get copies of the slides, as I understand it, after today, and there will be more detail on those. I'm sure that's the case for Thea as well. I see she's given me a thumbs up, so that must be right. The 2 cases that I'm dealing with, you can see the first on this slide here, the Plan B judgment. We saw this on the 27th of February, so relatively recently. I'm going to then be talking about the case of Sanders. Now, a little bit of a kick in the teeth for those of you like me that have had holidays cancelled. Both of these are airport-related cases. So it's not to try and remind yourselves of the fact that we're all stuck in lockdown and unable to travel, but of course there's still important cases that we need to consider. Plan B, for those of you that are aware of pop culture, it's not the Plan B that you see on the slide here. Unfortunately, we're not talking about the rapper today. We're talking about Plan B Earth, of course. And the judgment that we're dealing with, as you see on the slide here, has over 80 pages to it. So this is going to be a very simple overview of the case, but if you're looking for any bedtime reading during lockdown, when you get a cozy cocoa and your fluffy socks on, feel free to obviously have a look at it. I've also put on the side there a link for you to Plan B Earth's website as well, so you can see some quite interesting features of the case there. So let's crack on. Just a bit of background then, very briefly. This was a case involving the expansion of Heathrow International Airport, and in terms of the context, it's acknowledged that the UK needs to maintain its status as a leading aviation hub, and one way to do that was thought to be a 3rd runway at Heathrow. So those of you that have been following will already be aware of that, and the very controversial, shall we say, political debate surrounding it, particularly in relation to the environmental costs and global costs, actually, of doing that. So this decision concerns an appeal from the Divisional Court regarding whether or not the government were wrong whether or not the court was wrong to conclude that the government's policy in favour of that 3rd runway was produced lawfully. And in terms of additional context, of course, you'll be aware that the Climate Change Act 2008 aims to commit the UK to making a fair contribution to maintaining the politically recognised global climate change limit of 2 degrees, and the carbon target being set at 80% reduction of emissions by 2050, and that's compared to the baseline from 1990. And since then, we had in 2015, I think in December, the Paris Agreement, of course, that the UK government signed up to, in addition with a number of other countries, which rejected that 2-degree limit as being inadequate and committed to much below that, aiming for 1.5 degrees. So that's the context that we see to this case. I have put on this slide here some of the main issues for you, but the focus that we're going to have today is just on the climate change issues. As I say, this judgment is a very detailed one, considering lots of different elements. What I have done for you when you see the slides is I've put on this slide and the next one some key paragraphs of the judgment that deals with those other issues that you just saw on that previous slide. So do take a look at those when you get it. But we're focusing today on the judgment as it relates to the Paris Agreement. So you'll all be aware, I'm sure, that the Paris Agreement, of course, brings all nations into a common cause to undertake ambitious efforts to combat climate change. So as I said, moving away from the 2-degree limit. I've put a link on the slide to the Paris Agreement for those of you that want some additional reading after today, but we're really focused on paragraphs 184 to 261 of the judgment and 4 principal headings that were given by the court to the climate change issues themselves. So let's have a look at those then. Those were, did the government's commitment to the Paris Agreement constitute government policy on climate change, which the Secretary of State was required to take into account? Was the designation of the AMPS unlawful because the Secretary of State breached Section 10.3 of the Planning Act? Did the Secretary of State breach the SEA directive by failing to consider the Paris Agreement? And finally, did he err in his consideration of non-CO2 impacts and the effects of emissions beyond 2050? So looking then at the first issue, you'll see I've summarised it on the slide here, and you'll see throughout my slides I've put the key paragraphs for you to try and help you navigate that weighty document. So the government's commitment was part of government policy is the consideration here. We're looking at section 5 sub 8, which deals with national policy statements. And it tells us here that a national policy statement must give reasons for the policy set out within the statement. And that takes us to sub 8, which is that the reasons must in particular include an explanation of how the policy set out in the statement takes account of government policy relating to, amongst other things, climate change. So that's where this issue is born out of. Now, what the court says here is that that doesn't require the Secretary of State to follow or act in accordance with government policy, But what it does do is suggest that the ANPS should explain how the Secretary of State has taken into account that policy. Now, in terms of what government policy is, what the court says is that you should apply the ordinary sense to the facts of a given situation. Okay, so there's no warrant in legislation for limiting that phrase to the legal requirements of the Climate Change Act, which is what the Secretary of State was trying to suggest. Actually, the concept of policy is necessarily much broader than that. Okay, so there's no contradiction at all in terms with the express language of the Climate Change Act. The Divisional Court, in suggesting that there was and that the Paris Agreement wasn't government policy, fell into error in doing that. And as such, not giving effect to the Paris Agreement was an error. It wasn't giving effect to it through the back door when you look at Section 5.8 and what Section 5.8 means. And what the court commented on here is that the Secretary of State had been given legal advice in taking the decision that he did in terms of not looking at the Paris Agreement. And the court said that was a misdirection of law, and that fed through to the rest of the decision-making process. And because of that was fatal to the decision to designate the ANPS itself. So turning to the second issue then, this is whether or not there's a breach of Section 10.3 of the Planning Act. Just reminded us here as to what that sets out, but in particular it's a reference to the Secretary of State having to have regard to the desirability of, amongst other things, mitigating and adapting to climate change. And what the court says here is, look, the Secretary of State never asked himself whether or not he could take into account the Paris Agreement pursuant to Section 10. And that was clearly, therefore, an error of law. And this probably isn't much of a surprise given what the court's decision was in relation to the first issue. Now, there can be unincorporated international obligations that are so obviously material that they must be taken into account in the context of Section 10. And the court said the Paris Agreement is such an unincorporated international obligation. So I've put here on the slide the two paragraphs you really want to be looking at in the judgment in relation to that. In terms of the third issue then, so just to remind ourselves, this is in relation to whether the SCA directive is breached because of the lack of account of the Paris Agreement. And you'll all, I'm sure, be aware that Annex 1 to the SCA directive refers to the international level. So this is where at E of Annex I, it says the environmental protection objectives establishes at international, community or member state level which are relevant to the plan or programme. So that's the bit that you need to be thinking of in relation to the SCA directive. And what the court said is that you have to take into account objectives. That's not necessarily particular, precise legal obligations that means. And the Secretary of State has a wide margin of discretion, that's acknowledged, but no matter how wide that discretion is, the Paris Agreement is obviously relevant in the context of this case, okay? So moving on then to the fourth issue, this is, as you'll recall, whether or not the failure to consider the non-CO2 impacts and effect of carbon emissions on the environment was an error. And I've put on here the paragraphs of the judgment you need to look at for that. Really, though, the court doesn't say a great deal about it. It's a reasons point. Non-CO2 emissions and needs for future generations weren't separately dealt with by the court. I've flagged on here the paragraph that you need to look at in relation to that. But essentially, what the court's saying here is because of what they've concluded in relation to the Paris Agreement, all of the consequences flow and apply to this. So there isn't a great deal of detail in the judgment in relation to this particular point. So really, the key that we're looking at here is how does this decision really impact us? Well, it's clear it deals with a very specific statutory duty. So if you're dealing with that context in your case, then obviously there will be some relevance there. But of course, we do also need to remember as well that this case dealt with the policy as at the 26th of June 2018, and we have, of course, moved on quite significantly since then. We're 2020 now, fastly approaching June. So that needs to be taken into consideration when you're looking at whether this case applies to you. Similarly, I think, although many have said this is a surprising decision, we need to obviously remember that there wouldn't have been a free pass to consent anyway, because, of course, as per Section 104, a DCO application would have needed to have been decided in accordance with treaty obligations or domestic legislation. So that's also an important point that we need to bear in mind. In terms of how the case could go on to other planning matters you might be dealing with, in terms of decision making, I've put some of the references on the slide for you. But we know that paragraph 148 says that the planning system should support the transition to a low carbon future in changing climate change, and should also help to shape places in ways that contribute to radical reductions in greenhouse emissions. That's as far as it goes in relation to decision making with regard to policy. There's no explicit reference there to the Paris Agreement or anything else. And in terms of plan making, I've put on the slide here section 19(1)(a). So this is the statutory duty that DPDs must include policies that contribute to mitigating and adapting to climate change. And then, of course, in terms of the NPPF, paragraph 149, particularly footnote 48, which says that policies should be in line with the objectives and provisions of the Climate Change Act 2008. So again, there isn't any specific reference there to anything else, including the Paris Agreement. So that's really it in a nutshell. I just want to deal then very, very briefly with the case of Sanders. So you'll see here, this is a case in relation to significance, hence the picture that we have there. And I've put a bit of background here on the slide, but the short point really is that this is a Secretary of State decision for proposed development at Stansted Airport, and it's whether or not it was a nationally significant infrastructure project. So I'm not going to go through all of the background there, you've got it on the slide. It deals with the relevant provisions of the Planning Act, being section 14, which deals with what a nationally significant infrastructure project means. And we see there that in relation to airport-related development, we then go on to section 23(1), and it explains there that, among other things, it's only within section 14 if it involves an alteration of an airport, and then on to section 23(4)(6). What alteration of an airport means is only within that subsection if, among other things, the effect is to increase by at least 10 million per year the number of passengers for whom the airport's capable of providing air passenger transport services. Okay, so the Secretary of State's position in relation to this was that he said, look, I'm satisfied on a realistic assessment of the likely usage that the increase would only be 8 million. So it's not of national significance. The claimant says, actually, no, I think that's wrong. You've not looked at what increase is technically possible here, and you should have done that. And you also, in addition to that, haven't used your Section 35 discretion. So in particular, using flawed modelling, failing to appreciate the economic significance and so on. You can see that on the slide and in the case itself. So what does the court say? Well, in terms of Section 23(5), I direct you to paragraph 101 of the judgment. Ultimately, the Secretary of State is required here to make a judgment by asking what could be realistically achieved, not what might be technically or arithmetically possible. Okay, so ultimately the claimant was wrong. The Secretary of State took a fair and appropriate approach. There's further support for that conclusion at section 23 itself at 4b, where it says what the alteration is expected in terms of effect. So that's a very important qualification and makes it quite clear, the court says, that the assessment has to be grounded in reality. So you're not looking at what you could have, but what in fact is likely to be achieved. And then finally, very briefly, on section 35 and the discretion there, I've put the paragraphs on the slide for you. But ultimately, the evidence that was available to the Secretary of State at the time didn't support any allegation that the proposal was part of a wider or larger project. So ultimately, the Secretary of State was entitled to conclude that it wouldn't imperil climate change charges based on the government's policy on making the best use of existing runways. Okay, so that is a very quick run through. You'll see I've put a bit more detail there on the slide for you. We're going to move on now to Thea. She's going to talk to you about a couple of cases as well. So I'm just going to stop sharing, Thea, and hopefully you can share your slides now.
Yeah, thank you very much for that, Leanne.
No
Leanne and Nina, there are a couple of questions, I think, in the Q&As, if you have a quick look at those. I have heard of something yesterday for the first time called Zoom fatigue, which I wasn't aware of before. But I think a lot of people are starting to feel it. So I understand if any of you are feeling Zoom fatigue right now, but at least stay on for the first of the next lot of cases I'm going to talk about, because it's pretty important if you're dealing with any sites that are European protected sites and raise issue of habitats. So we will go there now without further ado. And what I might actually do as well, because I live in a house where there is someone who is being taught virtually by her school, and also a husband who's using technology. I'm just going to stop my video now and share my screen, and hopefully there won't be any glitches. So if anyone wants to comment in the chat about what this is a picture of, there's no prizes at all, apart from my respect, and perhaps those of other attendees. So comment if you know what that is, but it is a European protected site. And the first thing I'm going to talk to you about is the importance of getting habitats mitigation right, by reference to this case, Thorpe Hall Leisure Limited. And it's a really interesting case in terms of habitat mitigation. It involves land around the Lifehouse Spa in Thorpe-le-Soken. Again, if anyone stayed there, perhaps comment in the chat. I had an opportunity to stay there last summer while I did an inquiry for a couple of weeks, and ended up there with my whole team, the council's whole team, and the inspector. So that was an amusing experience when we were all trying to use the spa at the same time. But this was a proposal for 200 dwellings on land around the spa, and the proposals were refused by the inspector. And one of the reasons was the impact on nearby protected sites on the Essex coast. Now, the background to this inquiry was, at the time the proposals were going through the appeals process, the Essex Coast Recreational Disturbance Avoidance and Mitigation Strategy was being developed. And it was being developed by 12 Essex authorities, and it was in draft form, but it hadn't been adopted by the time of the inquiry. So the appeal proposals there were required to do two things. They were required to provide alternative and suitable natural green space on site, SANGs, and also a financial contribution. But in terms of the financial contribution, although that was largely set out within the draft RAMS, because that hadn't been adopted, there was a two-pronged approach. Either it would be paid in accordance with the RAMS, or there would be a financial contribution to the council if it hadn't been adopted by the time that planning permission was issued. So there was a problem, the inspector found, with that. And the problem was that the planning obligation, the inspector said, fell short because it failed to identify the specific visitor management measures. And also there was no requirement that the measures, such as they might have been, would be implemented before the first occupation of the properties. And that's a problem when you're trying to ameliorate or mitigate recreational impacts. So the inspector found that the proposals would adversely affect the integrity of the European sites, and we know why that's a big problem. It's a big problem because of this paragraph of the MPPF, which was triggered and tells us that the presumption in favour of sustainable development doesn't apply where a plan or project is likely to have a significant effect on a habitat site. So, bit of an issue for the developers, and they went along to the High Court rather disgruntled and said, well, it's not within our gift to implement specific measures or at any time or any specific time, because we're not in control of the European protected sites. And to top it all off, Natural England had been perfectly content with what was offered. Now, in terms of the specific measures, the court found that it was wrong for the inspector to have considered it was necessary for the developer to identify them. Essentially, those measures were set out within the draft RAMS. But as to the timing point, the RAMS in fact made clear that to be effective, measures did have to be implemented before occupation, which of course makes sense when you're talking about measures that are designed to mitigate recreational impact. And so the inspector hadn't gone wrong. So what are the key points then where there are habitats issues? Well, if you are dealing with a site where there is a habitats issue, be careful, think about it early on, and think about the way in which conditions and obligations might work together to mitigate that impact. And very often parts of the team might say, well, this isn't my role. It's not my role as a planner to consider the mechanisms of the legal agreement. It's not my role to consider what the precise mitigation is. But really think about this as a team. Make sure that you know the way in which the conditions and the obligations are to work together, that they are sufficient to mitigate the impact, and really be careful about timing. When are those measures going to be implemented? If it's recreational pressure, then of course it has to be before occupation. Another top tip is to think about the interaction between the SANGs and open space on site, because very often, although they're dealt with separately, perhaps one's dealt with by condition and one's dealt with by obligation, or dealt with in separate obligations, they have to work together in order to bring forward the biodiversity improvements that you're looking at, in order to make sure that there's space for people to walk their dogs, to remove that recreational pressure. So in terms of that multifunctional green space, are you asking it to do too much? For example, if you're trying to encourage recreation, is putting walkers and dogs into a specific space going to conflict with what you're aiming to achieve in terms of biodiversity, for example? Are you trying to accommodate specific species on site? So just be really careful, spend some time thinking about this issue, and hopefully you won't come unstuck when it comes to determination either with a local planning authority or at appeal stage. So the next case is Hudson, and this is a case that concerned proposals for a holiday village at Legoland. And it was a decision where the committee resolved to grant permission under the 2012 framework, and that was against officer recommendation, but then permission was granted in April 2019, of course, after there had been 2 further revisions to the framework. Now, Mr. Hudson brought this challenge, and he was, perhaps still is, the chairman of Berkshire branch of the Campaign to Protect Rural England, and he challenged the council's decision to grant planning permission. Now, just as a little bit of background, the development site is bordered on 3 sides by the Windsor Forest and Great Park Site of Special Scientific Interest and SAC. And the primary habitat reason for that European designation is the old, I'm not going to try and pronounce that word, oak wood. It has the largest number of veteran oaks in Britain and probably in Europe. And there were a number of complaints that were brought in this challenge. One related to the treatment and effect of veteran trees, and one that we'll come on to explore in a minute involved the absence of an appropriate assessment. Now, the basis for challenge in respect to the veteran trees was that there had been a big policy change between the 2012 framework and the 2018 and 19 frameworks, because you'll see there on the slide that in respect of paragraph 118, planning permission should be refused for development resulting in the loss or deterioration of irreplaceable habitats, including ancient woodland, and the loss of aged or veteran trees found outside ancient woodland, unless the need for and benefits of the development in that location clearly outweigh the loss. So that sort of benefits analysis that we're used to seeing repeated throughout the framework. Bit of a policy shift when it came to the next versions of the framework, because we're told there that development resulting in the loss or deterioration of irreplaceable habitats such as ancient woodlands and ancient or veteran trees should be refused unless there are wholly exceptional reasons and a suitable compensation strategy exists. And the court acknowledged that this was in fact a significant strengthening of protection afforded to veteran trees. So, as I said, another ground of challenge was that an appropriate assessment should have been prepared to consider the impacts on the SAC, and both the council and interested party actually conceded that point. They agreed that there should have been an appropriate assessment, and that hadn't been carried out. So, was it game over? You might think so. The answer is no. The court's findings were that in respect of the trees, the court found that members had concluded that the mitigating measures to be included in the planning conditions in the Section 106 agreement would ensure there was no harm to veteran trees. So in fact, in that case, the change in policy had made no difference. But I point out on this slide and the next that the court did in fact give some advice on good practice in respect of the common law duty to give reasons, which arose in this case, and you might recall from CPRE Kent and also Oakley. And the top tip on good practice from Mrs. Justice Lang was that local planning authorities should set out adequate reasons in the minutes or the annex thereto, and not rely on a transcript of the meeting as the source of their reasons. It's often difficult for members of the public to discern the reasons from a lengthy transcript in which members are expressing a different view, particularly when, as in this case, only an audio recording is posted on the planning website. So, the council had tried to argue that the officer report did the job of an appropriate assessment, but that didn't wash. It was so short that the court wasn't very impressed with that. But the judge was satisfied that given all the documentation before the decision taker, the extensive consultation that had been undertaken, that it was highly likely that the outcome would not have been substantially different if an appropriate assessment had in fact been undertaken. So the learning points from this case are that in relation to reasons for a committee departing from an officer report, see what Mrs. Justice Lang said. It's useful to include a summary of those reasons so that people don't have to go searching around for them. If you're looking at designated sites and veteran trees, obviously get an ecologist on board early, because getting it wrong will be potentially something that might prevent the grant of planning permission or lead to a quashing later on. So get that right early on and be aware, of course, of that policy change. Critically, review the reports produced and make sure you're aware of policy and case law changes that might require a different approach. Now, it does strike me with this case that it could have gone differently, particularly in respect of the complaints over the appropriate assessment. So again, if you're dealing with habitat sites, play it safe and do the appropriate assessment. And the final case, this illustrates an important point really about cumulative effects. And cumulative effects, certainly in the work I'm doing, are arising all the time in respect of transport impacts, in respect of air quality. And of course, air quality at the moment is a really big buzz topic for local objectors. Early on in my practice, it seemed to be heritage. Everyone wanted to talk about harm to the historic environment, but now it's very much air quality. And although this challenge ultimately failed, there's a long history, and the challenge prevented this site coming forward for over a decade. So really important to be aware of taking into account cumulative impacts. So in this particular case, there was a challenge to the screening opinion in respect of proposals for 160 homes in Hemsworth, Yorkshire. And that complaint, as I said, a failure to consider cumulative effects of the proposal. And the history, as I say, is outlined there in that the site first achieved planning permission in 2008, and permissions were granted and then they were quashed, so on and so forth. And this went around in a bit of a circle. At the time of the challenge, the site was in fact allocated for housing within the council's adopted site-specific policies local plan and had an indicative capacity of 179 dwellings. So the application was very much in line with the allocation. Now, it's right that here the court was generally unimpressed with the challenge, but it really demonstrates how objectives can get in the way of much needed and acceptable development, even where it's allocated. And ultimately, as I said, objectors lost, but the site was in the system for many, many years and delayed from coming forward. So the top tips: always consider cumulative effects. They still come up frequently. Take a belt and braces approach. Get the reports done. If in doubt, make sure that you bottom the issues out. Air quality objections are in vogue. If you're aware of local objections, don't simply ignore them because they're from members of the public and they might not be taken as seriously. In my experience, it can be the case that local objections, even based on anecdotal evidence, can seriously cause problems when it comes to inquiry. So much better to approach those issues head on at an early stage. If there is a challenge, think about how it might be remedied tactically. Can you get another screening opinion? Can you make another application using your free go? But essentially, take legal advice always if there is a challenge. That is what we are here for. Thank you very much. I can see there's some questions. Whatever questions there have been, we'll do our best to answer them. As I said, either messaging you directly or posting answers on LinkedIn or at a future seminar. But it remains just for us to say thank you very much for joining us today. Very good to see you all. Enjoy the rest of your day and hopefully it's sunny where you are. Bye.
Thank you,
Bye-bye.
everyone.